I'm Alice,
And I'm Brett.
and this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my testy co-host, Brett.
Testy. I can take that, Alice. I feel like
You are testy.
I feel like I'm in a fine mood today, but that's fine. That works. That works.
You're prickly. That's why we love you. But I was going for the pun. You have nothing to
Like
do
a
with the
pear.
descriptor, per usual, because we are here to talk about none other than West Memphis 3 and DNA testing. The topic that has been blowing up the true crime social media world. And we're here to knock it down a couple notches and just tell you what the recent Supreme Court decision said about DNA testing.
Yeah, and there's a lot of interesting things all sort of wrapped up in this. West Memphis 3 is always something that people like to hear about, but this is really more about DNA testing, when you should do it, when you shouldn't do it, and what law says about it, particularly in Arkansas. If you've been listening to the legal briefs since the beginning, we talked about this, seems like a long time ago, because this has been sort of percolating through the process for a while. And
by the way, this just shows you how long the legal process is, which
Yes.
is like a whole legal briefs in and of itself as to like how much justice there is when the entire legal process is so long, so drawn out. I think we covered the district court opinion, 2 years ago at this point? A year and a half ago?
About 2 years ago. I mean, it was very early on when we were doing it. And you're right. I mean, it is a testament to just how long things take. It's a very slow process. I mean, the wheels of justice grind very slowly. They really do. And it's one of those things where, once you're convicted of a crime, you're going to spend some time in prison. Even if it turns out the conviction was utterly flawed and it should be thrown out and everything, you're going to spend a while in prison just because it takes so long for the appeals process to roll out. Sometimes you'll see people ask for an appellate bond where they actually get to stay out of prison. And the purpose for that is if you have a really good argument that your conviction is invalid, you can stay out for that very reason because it takes so long. This is a little bit of an aside because we're way past the being in prison, being let out of prison point in the West Memphis 3 case, but it is something you can do.
And kind of on the other flip side of that, that's why a lot of times you see a sentence of time served, which is actually what Damian Eccles got when he entered an Alford plea. In this case, unrelated to this particular emotion that we are about to talk about. And that's because when you have time served, it's usually a long time if you're waiting through the appellate process. And in his case, many, many years. And for many other people who are serving time who ultimately may get some vindication in the appeals process. With that, Brett.
So all that this has been percolating for a long time. And if you listen to our initial thing, we talked about this as sort of through the lens of habeas, as a way to explain to you how habeas works. And one of the things that the trial court was very concerned about, there were several issues the state raised about why they thought this motion was improper. They basically made 3 arguments, all 3 of which were dealt with in a recent Supreme Court opinion we're going to talk about. One of them was sort of a venue issue. They filed the motion in the wrong county. I never really understood that one, to be clear. I never really understood
especially
exactly what was going on with that.
In custody.
Yeah, exactly.
Which actually goes back to what we're about to talk about.
The fact that they entered into an Alford plea, which was premised on the idea that everybody's going to sort of go their own way, and yet you still have these motions by Damian Eccles, if not the other 2 West Memphis 3, to test DNA, even though you have the guilty plea and everything's supposed to be done, and yet you still have this. And the state was like, hey, that's not really what you're supposed to be doing. But the big issue was an issue of statutory interpretation, that the DNA testing statute is part of habeas in Arkansas, and that under the Arkansas Supreme Court's precedent, and really every state's precedent and the United States Supreme Court's precedent, in order to avail yourself of habeas, you have to be in custody in some way or another, either actually in custody in prison or under something like a parole or a supervised release where you're not in prison, but you're still under the control of the state. And at the time we said, look, this is the right decision by the state court, And the only way this is going to change is if the Arkansas Supreme Court changes it. You're going to have to go to the Arkansas Supreme Court to get relief on this. And that's what happened. So Damian Eccles appeals this. It ends up all the way in front of the Arkansas Supreme Court. And they issued an opinion. There's seven justices. So this is a 4-3 opinion. It took them a really long time to write this. And I don't think they even had oral argument on it. It's not a long opinion, which tells you something about what was going on sort of behind the scenes of the Arkansas Supreme Court.
For those of you who may not know, what that means is it's not about writing the opinion. That's not what took so long. It was getting votes, right? It was deciding which way is going to come out, especially if it was so close.
Right, exactly. And in the end, the Supreme Court essentially said that even though the statute is under habeas, it's not necessary in this narrow circumstance for the person who is bringing the challenge to be in custody. That was sort of the major. They dealt with the other two issues too, but the major thing was that. And they did it through some statutory interpretation. It's a short opinion. It's not long. There's not a lot of citation to law, so you can read it. We've made it available on the gallery. If you're in the gallery, it's on the gallery. It's easy to find, but we'll try and link it maybe to this episode so you can read it. But it's an interesting opinion, and so is the dissent.
So real quick, have we done a legal briefs on statutory interpretation?
We did.
We have? Yeah, we did. Okay, so you can go
Yeah.
listen to that. We've also talked about it in a lot of our different cases because it is a method in which to interpret statutes. That's literally what it means. And how you interpret statutes, at least in one method, as is explained by the majority opinion in this case, is called plain language or plain text statutory interpretation, which is exactly descriptive. You look at the words of the text of the statute and don't look outside of the words. One thing to note, and I think we noted this in our statutory interpretation legal briefs episode, is that you don't actually look at the text completely in isolation of everything else, right? Like you can imagine the dog ran away. Statutory interpretation, plain text, doesn't mean you look at the and then dog separate from everything else and ran separate from everything else away, right? And then you look at the entire text and then you also look at it in context of maybe the paragraph it's in. Why I bring all this up is the statute at issue here is Arkansas Code Annotated Section 16-112-201 to 203. And it's called Act 1780 in this particular opinion. If you go Google that, I know there's a lot of numbers, sounded like a code. If you just go Google it, it's very interesting because there's a title to that statute. And you'll notice a lot of words, a lot of titles, lots of sections you may not understand, but one thing may stand out to you. And that's in the title of that statute is habeas corpus. And we had talked about in the last legal briefs about the district court opinion was that habeas law is very clear in Arkansas Supreme Court, as it is consistent with just about every state Supreme Court that has considered habeas. And that is the purpose of habeas is you are in custody and you are challenging the fact that you are in the custody of the state. So if you are not in the custody of the state, you don't have a right to make use of this statute that literally says the state has your corpus, your body. And that's why you get to bring this particular claim.
Yeah. And reading this opinion, it's interesting to read this opinion because when you read the majority is, well, number one, it's remarkable how short it is, particularly the actual part of it dealing with this question, because there's a lot, as Alice was saying, habeas corpus goes all the way back to the Magna Carta. There's a lot you could talk about. The dissent talks a lot about sort of the history of habeas and cites some cases and everything else. But the majority takes a very straightforward way to do this. They essentially say that we're just going to do the plain language of the statute. And the statute says, if you've been convicted of a crime, you can test DNA, essentially. That's essentially what it says. And so since Damian Eccles was convicted of a crime, he can test DNA. Case closed, right? And that's how they do it. And that is very straightforward. So if you want to know how the majority got to its decision, that's exactly how they did it, right? They looked at the plain language of if you've been convicted, therefore you can do X, Y, and Z. It's really interesting that they actually
copy and paste the entire language of the text of the statute before they get to the plain language interpretation. And it starts with saying one can be granted relief under habeas if one is convicted, et cetera, et cetera. And that's why I said plain language is the proper way of doing plain language interpretation, is within the context of everything. And so you're thinking, well, okay, if they recognize that this is a habeas corpus statute, what do they do about the habeas jurisprudence that they have? Well, this is really interesting. They kind of dismiss it in about one sentence. They say, we're not going to delve into what the state said because the state is trying to argue the backdrop of habeas corpus by saying it's legislative history. These are all buzzwords because when you do plain text statutory interpretation, it is like a rule that you look at the text before you and you don't bring in outside explanation of what happened. Legislative history is an example of outside of the four corners of the statute. Legislative history, imagine, is like the backdrop of maybe what was happening. Was there a war happening? Was there, some sort of public event that caused this law to be passed? And then there's the dialogue back and forth. You have people giving speeches on the floor before there's a vote taken. That's all part of legislative history. And typically, if you read Brian Garner's interpretation, or I forget the name of the book, but Brian Garner is a professor who's written a lot about statutory interpretation. He's written about it with Justice Scalia, who is now passed. And most law students have heard of or abide by the interpretive rules that Brian Garner has laid out in his many books. He's going to say, yes, legislative history, that typically is something that you don't get to bring in for plain text interpretation. So it's really interesting because the majority opinion uses all of these tools and uses all the right language and uses the right steps, yet in doing so kind of ignores the context of the statute, which, by the way, it can do because it is the Supreme Court. So no one's going to overturn them. And this is why we said the district court can't come out the other way, but the Arkansas Supreme Court can.
What is really interesting about this is a good example of a court using the language of interpretation to mask what I think is just a nakedly activist decision. I think this court thought it was unfair that this evidence was not tested. I think they thought it was unfortunate that the legislature put this provision in the habeas statute because they didn't have to put it there. They could have put it somewhere else. And so in order to reach what they thought was the fair decision, which is, why aren't we going to let them test the evidence? Let them test the evidence, right? I mean, which is frankly what you hear most people say. Like when you hear most people talk about this, they're just like, well, they should be able to test it. Of course they should be able to test it, right? But the thing is, courts typically say what the law is, not what they want it to be. So they have to interpret it based on what it is. And if you read the statute or you read the opinion, they say some really interesting things. Like they say, when the language is plain and unambiguous, there's no need to resort to rules of statutory construction, and the analysis need to go no further. It's important for them to say that because if they do any statutory construction whatsoever, it cuts against their opinion. And the problem is, the argument here is not that the statute is ambiguous, because when you have ambiguity in a statute, then the rules generally say you can start looking out to all of the things. It's not that. The question is, what does the statute mean? In order to do that, when you're doing plain text analysis, like Alice was saying, you consider the words of the statute in para materia with the rest of the statute, which means you consider it with everything else around it, because that's how you interpret plain language. Like Alice was saying, if you take a sentence, if you just take a sentence and read the sentence, you can know generally what the sentence means, but without the context of everything around it, you won't actually understand it. So a good example might be, we're using dogs here, so we'll just keep using dogs. Let's say that someone passed a law, some state or city or whatever, and it said, no dogs allowed. And it put it in the park section of the code, right? And then let's say your neighbor doesn't like your dog. So they sue and they say, in this state or city, there are no dogs allowed. Well, under the Arkansas Supreme Court's interpretation, you'd lose. The statute says no dogs allowed. We don't need to go any further. Very clear statute. No ambiguity there. No dogs allowed. And you would be saying, wait a second, guys. That's in the park section. It's talking about in the parks, not just in the state. And the statute doesn't have to say no dogs allowed in the park when it's in the park section, because everyone would understand you're going to read that with the rest of the code. And here, the Arkansas Supreme Court makes this very conscious decision not to do that. And what's amazing about it is it's even worse because, as Alice said, it's almost as if it says no dogs in the park and they just ignore the in the park and take your dog away, because it starts off with in an action in habeas. So even the statute itself is making clear we're talking about a habeas action here, and we're talking about a
Which
habeas
they
action,
put in their majority opinion.
right?
Like, I mean,
They,
again, there's like the statute. You guys can look it up yourself. You'll see in a habeas action. But when they copy and pasted it, they didn't actually pick and choose. They actually copy and pasted the entire statute. And the part about it being a habeas action is in the majority's opinion, which is why I had to read this opinion 3 times to understand it. Because I was like, wait, say what? Am I losing it? You just said it was a habeas action, and the jurisprudence is very clear. And something Brett just said is really important, because a lot of you may be saying, well, who cares? It is unfair. Who cares if they're activists? This DNA should be tested. What's the big deal? I'll get to the big deal part, which is that this applies to all other cases and what this means for the person who wants you to ban your dog from the city completely because of the way that statutory interpretation is now explained by the Arkansas Supreme Court. Damian Eccles can have this DNA tested. It's just not going to be allowed by the Supreme Court if they followed the rules of statutory interpretation. The reason that he's even able to bring this at all, he's not really able to bring it, but the reason that this kind of DNA testing is under the habeas statute is because the legislature thought, okay, when you are in custody, and you want something tested, we're going to allow that. Guess what they can also do? They can also create a separate cause of action that is not within habeas. Now, will that take longer? Yes. But did this Arkansas Supreme Court take 2 years from the time the district court made the decision and then decades since the original conviction? Yes. So we're not saying that it's not impossible. It's just that it goes back to the very founding principles of the country, which is that there are 3 separate branches of government that are not supposed to interfere or step on each other's duties. The legislature is supposed to make the laws. They did make the law here. And in doing so, we'd like to think that they thought about when would they allow something like this so that there's finality in convictions. And they thought, okay, it is when someone is in the custody of the state, because we think that they have a heightened level of imposition by the state because they're being held custody by the state. So we don't want every single conviction to be collaterally attacked by the mere suggestion that DNA could overturn the conviction. And by the way, the dissent in this case points that out exactly. They said DNA had nothing to do with the original conviction. And so they give 3 very clear reasons. And we'll talk more about the actual decision, but they boil it down to 3. The dissent's like, look, this is not statutory interpretation. This is purely, completely ignoring the fact that this statute is a habeas action, not an independent cause of action. Like, put your feelings aside about what you think about Damian Eccles and the West Memphis 3. We are supposed to care about these things because our decisions are supreme among all Arkansas courts, and they have to be applied in every situation, not just Damian Eccles' case, not just West Memphis 3 cases, not just cases that make national or international media. This has bearing on every single defendant before us. And what we're doing here, and this is absolutely right, they're like, look, you are telling every single judge and every single prosecutor, don't ever offer an offered plea, because there's absolutely nothing that you get out of getting an offered plea, because it's not a real conviction. They can attack it collaterally. Usually you get that because, you make a calculated decision as the defendant, even if you maintain your innocence. But you're like, man, the evidence is all against me, which there was a mountain of evidence against him in this case. So he took that instead of continuing to be on death row.
and it's one of those things where the dissent, one thing they say that I think is wrong. I mean, they say the typical thing that everybody says when you dissent, which is, this is the end of the world. They've blown this massive hole in habeas. Now there's no longer any finality. What are we doing? You don't even have to be in custody anymore. Anybody who's ever been convicted of a crime now can come back and claim this. Yeah, see, the thing about it when you're being activist is you're usually not consistent. So I'm pretty sure that the Arkansas Supreme Court, if this issue came up again in case it wasn't famous, would fix it. They would be like, oh, well, it's a little different here. And this is all the reasons we're going to ignore that last opinion, which was just its own thing, right? Which is probably what they would do, because typically this is easy black letter law stuff about habeas. You have to be in custody for habeas. You always have, or
Which, by the
some
way,
sort of other thing.
I go back to, a question someone had asked us once. They're like, if you're convicted of a crime, who would you hire as your defense counsel? I still say, I don't know, a fantastic Netflix producer to make all the media attention on me, because that's what's happening here, right? I mean, we see this over and over. This is not the only case that gets kind of special treatment because of all the media attention around it. So I still stand by that answer. If I ever get charged with anything, just get a great documentarian on my case or a great podcaster on my case. Brett, you're on the hook.
And the thing about the Alfred plea and the way it plays in, I mean, there is a certain sort of push and pull on that because it is a guilty plea. I mean, some people act like it's not a guilty plea. It is a guilty plea. Now you're saying I'm only pleading guilty because I
The weight of the
recognize the
evidence.
state. Yeah, the state has enough evidence to convict me, and I don't want to roll the dice on that. But I am innocent, is what you're saying. And the Supreme Court, it used to be you couldn't do that. It used to be the rule was no. Number one, we don't want people who are innocent to plead guilty, and number two, we want people who are guilty to admit their guilt if they're going to plead guilty. And Alfred came along and was basically like, well, people should have the right to gamble, right? Basically, or to choose not to gamble. They should have the right to go ahead and do the thing that's in their best interest, which may be pleading guilty even when they're not. But it is a guilty plea. And there's an extent to which if they had wanted all of the tools available to them. I mean, look, if somebody confessed tomorrow, right, they could use that. If they knew for a fact there was some DNA they were going to get, I mean, that's a better argument to challenge. This is more of a fishing expedition. I mean, this is like, there's some evidence that was never tested. We want to test it. And it doesn't really fall under the exceptions to their particular Alfred plea or generally what you think of Alfred. So it's a little bit outside of that. So I understand why the state's kind of like, guys, this is supposed to be over unless you came up with something big. And this just feels like you're just wasting everybody's time. And we're going to talk about DNA testing in a second. There's not much more to say on this opinion because, I mean, this is just how it is. But I think what's interesting about it is the willingness of the Arkansas Supreme Court to do what Alice said. I mean, basically, I think if this had been a no-name plaintiff, number one, it would not have taken them a year and a half to do this. I think what they were waiting on, they were hoping either the state would go ahead and concede and say, you know what, fine, just let them test the stupid evidence, right? Or the Arkansas legislature would change the law, which apparently there's been some movement to do that in the wake of this opinion to clarify one way or the other, either that no, you can't do this unless you're in custody, or to move it out of habeas and make it more readily available to everybody. So there's debate going on in the legislature about that and maybe how to fix this. And I think they were kind of hoping one of those things would happen. Neither one of them did. And so eventually they had to release this opinion because it's not long enough. And it feels like everybody was pretty much in their camp for it to be back and forth or there's a wavering justice. To me, I don't really see that when you read the opinion. So I think there was some more stuff going on back in the behind the scenes. And look, I mean, this is not, it bothers me as a law guy. Like, I don't like it when courts feel like they're just kind of ignoring the law. But the thing about it is, more so in the states than in the federal government, the judges are still more political animals. They're more responsive to the people than maybe they are. In some states, they're very responsive to the people. I mean, in some states, they run in partisan elections, and they run on my opponent lets people out of prison. You don't have to worry about that from me, right? I mean, it's a very sort of responsive to the voter type thing. So, I don't want to be too hard on them because I understand why they did what they did. But if you're just looking at it purely from a legal perspective, I think the dissent has a much stronger argument for how this statute should have been interpreted than the majority ended up with.
Basically, what we're saying is if you're studying in law school and trying to understand statutory interpretation, don't read this opinion as statutory interpretation because then you'll be very confused about how to properly apply it.
Yeah. So let's talk a little bit about DNA just in general, because I think there's also just a question of why does the state care? Why won't they just let them test this? And I look, in this, what's going to happen now, it's been presented, and even I've said this, as, well, now they're going to test the evidence. Well, not necessarily. What's actually going to happen, all that's happened now is they have a right to the hearing to try and test the evidence, right? I mean, this was a bar, really. I mean, this was just like, you can't even get into court, because there's no vehicle for you to get into court because you're not in custody. So therefore, this doesn't lie under habeas. Therefore, the court has no jurisdiction to even consider it. So now what you'll have is you'll have some sort of trial level proceeding where the state will either acquiesce to testing or they will fight testing. And at that point, you're going to have some sort of evidentiary hearing. And I imagine the things that you're going to hear are things about the evidence and the state's duty to preserve evidence and not destroy it. Now, why is that important? Alice and I just went to Othram. It was great. It was awesome. We learned a ton. And one thing they talked a lot about is DNA. And we talk about this all the time, but DNA and the fact that when you test it, it is destroyed. Paul Holes was there, and he told a story about one of the cases he had where they had this great DNA sample with tons of DNA. I mean, they had enough DNA, they should have been able to test it 100 times. And they sent it off to a lab. The lab consumed the entire sample and did not get a DNA sequence from it.
And they didn't need to.
Right.
Think about if you had like a big cloth and you needed to like color test, and all you had to do was like cut off a strip of the fabric to like go and match the right color. But instead you took the whole thing and it got like burned up. That's basically what happened, is the lab didn't need to consume the entire DNA sequence, but it did because nothing kept them from doing it.
And Paul Holes talked about how devastating this was, because at the time they didn't know if they had any other DNA they could even use. And it ended up being sort of a story about Othram and their amazing techniques, because they had DNA that essentially was like in formaldehyde and like all this other stuff that everybody said there's no way you can ever get a DNA profile out of it. And Othram spent like a year and a half essentially with not that DNA, but they put a bunch of DNA in formaldehyde that, wasn't the crime victims, and spent like a year and a half trying over and over again, testing this out, failing to get any DNA, until finally they had perfected a method to get DNA from a sample in formaldehyde. And then they were able to pull that DNA out of the victims, and all of a sudden somebody who did not have an identity had an identity.
And that was really important, right? Because I had never thought about the labs, and I don't think every lab does this, but this is what Othram does, is they develop the research. They have a research side of their lab to just work on whether they think they can be successful in extracting and getting something usable out of the DNA that they are sent. And so this is going to be really interesting, because at the hearing, I suspect that it will be about what DNA there is, what the technology is, and what different labs will say is the probability of building a usable profile with the available technology now. And if the kind of unanimous result from all these lab experts is that based on what we have, because it's porous, or it's been wet, or it's been in formaldehyde, or it's been decayed, or there's mud, whatever sort of condition the remaining DNA is in, if they all say right now, based on the technology we have, there's give some percent, 5% chance that we can get anything usable out of it, I can imagine that the state is going to say, well, because of that, today we're not going to get anything out of it, so we should not expend all this DNA, because maybe in 5, 10, 15 years, there can be technology to make something usable out of this. So we should wait, because our duty is to preserve the evidence and not be risky with it. 5%, you got to weigh your evidence here. They're already out of prison. Why kind of burn up your last remaining chance if the technology is not going to get you any answers? And you can imagine that the judge is going to agree with them if that is the kind of statistics or the lack of kind of any answer based on testing. And you can see that that may result in them losing the right to test. And I think that would be upheld, because you're basically trying to argue what's the purpose of testing? Why burn it up now? So that when technology gets better, you can't test it and you're afraid what's going to be on it. So this is really important, because I see a lot of people saying the state would never want to test anything because they believe they have their guy. That is not actually where the state's coming from. The state is coming from that they have a duty to preserve evidence, and kind of just throwing it out to be expended for very low probability of getting any answers is not in the state's kind of fiduciary duty of the evidence.
And I think of it this way: if the West Memphis 3 are guilty, then their interest in testing the evidence is pretty low. If they are innocent, then the victims have an equal interest in testing the evidence, particularly because they're not in prison. If they were in prison, you could imagine their interest is a little higher. But if they are innocent, then they both want to be acquitted, or exonerated, and the victims and the victim's family want the correct person to be convicted. So, in a world where the only interest we cared about were the West Memphis threes, like if that was the only interest even at issue, then let them decide, right? It's all in their interest. If they're willing to roll the dice on 5%, let them roll the dice on 5% and see what happens. But that's not the world we live in. So, because of that fact, I think if that's what happens in evidentiary hearing, and this is all just who knows, and we're speculating about what would happen in a hearing, but presume that is what happens. Presume even the expert who comes in to testify for Damien Echols says, yeah, I mean, most likely we won't get anything and we'll destroy all the DNA and that'll be it. We can never test it again. But we feel like we got a puncher's chance at it, right? I mean, if that's what they say, then I think the state's going to argue pretty vociferously, like, then we shouldn't do it. If they go in and say, no, don't worry, we're going to test it. Our technology, imagine it's Othram. We've done this 1,000 times with this exact kind of DNA. Every time we've gotten a result, we're going to get a result. Then the argument, well, you're going to destroy evidence, is much weaker, basically non-existent, because you're not actually destroying evidence. You're going to get a result. Or if they come in and say, no, you got it all wrong. We can tell there's, this many nanograms of DNA. We're only going to use a few of them. So there's still going to be DNA left. If the technology advances in the next few years, which it will, we'll then be able to test that. If they come in and say that, that's not a problem. The issue is if they come in and the argument is this is a one shot and we've decided we're going to take our one shot now with the technology we have now, not the technology we're going to have in a year, and we got a 10% chance of getting anything, then I think you got a judge who's put in a position where they have to decide, is this a circumstance where we allow this evidence to be destroyed? Or do we say, no, you're going to have to do better than that. You're going to have to bring in a different, somebody's going to have to come and tell me they got a much better chance than that. And Othram, we keep using Othram as an example because we know so much about him. Othram would be able to say that. Like they would be able to testify and either say, we are certain, as close as you can be in science, we are certain that we will get a result, or we are not. And what was very impressive about the entire presentation when we were there for a day was Othram talked a lot about how they understand that this evidence is someone's last chance at justice or someone's last chance to get their identity back. And that if they aren't sure or as close to sure as they can be, destroying that evidence is a huge, huge risk. And I really appreciated that from them, having that sort of humility, because a lot of times, people on the cutting edge of science don't tend to be humble people because that's how they get where they are.
And something to put this into perspective, we are talking as if this DNA is going to be the golden bullet and it's going to solve everything. DNA and like genetic genealogy can be the golden bullet if you have a Jane Doe who has been left for dead on the side of the road and completely unidentified for decades. Like these were a lot of the cases we were talking about at Othram. That, whatever chance you have to kind of identify who that person, because you have no other leads to know how this person ended up here, who may have done this, who brought them here. That could be like a golden bullet to at least know the person's name. So you can stop calling them Jane Doe, give them a proper burial, and then start finding family members and piecing together what happened to that Jane Doe. In this particular case, this is where the dissent in the Arkansas Supreme Court was helpful, because in just about a paragraph, and obviously the West Memphis 3 case is much more complex than this, but they kind of lay out some of the evidence against Damien Echols, and it had nothing to do with DNA. DNA played a part, some part in this case. DNA plays a part in a lot of cases. Does DNA always lead to a conviction, or is it the only thing you need for a conviction? No, it's kind of like when we say you have an eyewitness for every single conviction. No, absolutely not. When you have a mountain of circumstantial evidence, for example, that can point to a very strong case against someone. So in this particular case, we don't actually have Damien Echols coming in and saying, if we have this information, it will completely exonerate me. He's saying there's something that hasn't been tested. That's a very different thing. And so even if that 5% chance or whatever, let's say they come in and say 100% chance we can get something usable out of it, based on the information we have right now, we do not know that it will be relevant for this particular case, or that it will lead to exonerating him or even finding out who really did it, right? So that's important to remember here. In fact, there are instances where DNA comes back and it doesn't help us at all in our cases, right? Because that it's lots of people touch things all day long. Your DNA is all over the place. You may not know where it is, not just in your house, not just in your car, the places that you walk, restaurants, where you sat. There are so many places that your DNA could be. So I think all the talk about DNA has people being myopic about the importance of DNA. It can be incredibly important in the right circumstances. And part of the dissent's point about DNA in this case is that they haven't made the case that DNA is kind of what's going to exonerate Damian Eccles here, or that it's going to be enlightening to this case whatsoever. It might be, but it might not be.
Yeah, and sort of the alternate theory that has been advanced, I think, in some ways undermines the argument for testing if you're not certain you're going to get a result. Because if your alternate theory is that it was one of the parents, I mean, it depends on how far in the Paradise Lost trilogy you've made it. If you're only on the second one, then you're sure it was John Mark Byers. If you made it to the third one, then John Mark Byers is a saint, and it's clearly Terry Hobbs who did it. Well, the problem is both of those people are parents or step parents of the kids. So, like, let's say you found their DNA on the shoelaces of their kid. That's nothing. Like, that doesn't tell you anything. That tells you that maybe they tied their shoes for them at some point. I mean, I'm going to go out on a limb and say my DNA is all over my kid's shoes,
I
right?
was gonna say I literally tied 3 kids' shoes at church today. Like, the kids were all running around and tripping, and I literally tied 3 kids' shoes today. I don't know who they were, but my DNA is definitely on
Yeah.
their shoelaces.
Alice is a serial killer now, like.
Apparently.
So if your theory was no, we've got a really good lead on a serial killer, right, who was in the area and had done some other things, and there were some people who said that he confessed, and like if you had that, then it's like, okay, now let's test those laces, and if his DNA shows up, well, wow, boom, like we've got the silver bullet. So I mean, these are just all things that a judge is going to have to consider, and I think if you can be just like, oh, test the evidence, you should test the evidence, there's evidence, you should test the evidence, right? I mean, you can say that if you want to, but the judge is not going to be in that position. The judge is going to have to weigh all of these various things and factors and decide whether or not to do this, since destruction of the evidence is at issue. And that's the thing about DNA. We talked about this a lot, and I feel like people miss it. You are destroying the evidence when you do it. So once you do it, it's gone. And if next year the greatest, most amazing DNA technology that can get with one micro speck of DNA can tell you exactly who it is comes out, it's too late. It's already gone. If this evidence had been tested 20 years ago or 10 years ago with the technology they had then, number one, they wouldn't have gotten a sample from it then. But number two, it would have been destroyed. And so now with MVAC and everything else, sorry, we tested it before and it's destroyed. You can't test it now, right? So, I mean, that's the thing that you have to remember. And I think we're going to see in the next step. I kind of wonder if at this point the state is exhausted with this case and may just say, you know what, who cares? Like, you want to test it, test it. Damien Eccles is already raising money to test it. Go for it. Go forth. May you find evidence of an alternative person. I wonder. I just wonder about that, because this has been going on now since 1993 or whatever. They've been fighting this DNA fight for several years at this point. It's one of those things where a lot of the players are different. I mean, DAs roll in and out, AGs change. The players involved are all different. So it'll be interesting to see what's next. If I had to guess, I'd probably say I think what's next is they're going to test some of this stuff, some of it. I don't know if they'll test all of it. Maybe they shouldn't test all of it for all the reasons we've just been saying. But it'll be, we'll be watching, obviously, and we'll let you know what happens.
That's basically it. But the opinion is there for you guys to read if you want to read it. But that's all it means now. It's remanded now to see if there is going to be testing. So it's never quite as exciting as you think it is. This was just a bar that said, you don't get to raise this at all. And now the Supreme Court has basically opened the door to allow them to go back to the district court to see if they get testing. Yeah, I think they're just probably going to test it and probably not find anything.
I think that's probably what's going to happen. I mean, the most likely thing is they're going to test this DNA. They won't find any DNA. The absence of evidence will be presented as evidence. We didn't find any DNA, so therefore Damien Eccles must be innocent, even though we didn't find any DNA. They'll find some like unknown touch DNA. They can't attach to anybody in the in the case. And maybe they can do some sort of genetic genealogy to figure out who that is, or it'll be whoever made the shoelaces or something, or it'll be cops. I mean, there's all sorts of stuff that might happen, and maybe it'll be a blockbuster. I mean, you never know, but I would think the chances of blockbuster are low, but I think the chances they'll end up testing it at this point are high. If I had to.
Well, maybe we'll find out another 2 years at this rate.
Maybe we will. And it's just funny. I mean, people in the chat are like, no, the state's worried about getting sued. Guys, they're never going to solve this case. Okay. Like, spoiler alert. It doesn't matter what they do. We're never going to actually know who did it. The West Memphis 3 are never going to even if they get exonerated one day, just like because some governor decides to pardon them, there's not going to be some big lawsuit. Like, this is one of those cases that just, unfortunately, will be a mystery forever. So there you go. Now we don't have to cover it. That's all I got, Alice.
Yeah. And here's the thing. If this is not what you wanted to hear, we're not here to make up things. Like, we are interpreting the opinion for you because I think it's important for everyone to understand how these opinions are reached and where they are within the procedural process. Because as we said at the beginning, the justice system takes a long time. This is one of a step towards getting tested. So there are still many steps to go. And because this garnered a lot of opinion, people were just like, oh, this means everything gets to get tested. That's not right. And that's kind of the point of us trying to explain the judicial process here. Do you have anything else to add, Brett?
No, I don't think so. I mean, I think this, for the people of Arkansas out there, this opinion is not really going to change much. As I said, I don't think this is going to open the floodgates. If it does open the floodgates of some, like the dissent seems to be concerned it's going to do, which I think they're wrong about, then I would just assume there'll be some sort of legislative fix. But I think for this particular case, I think your most likely outcome is they will end up testing this stuff.
What I think we already know, for all of you asking us to cover West Memphis 3, is that when we cover a boring statutory interpretation Supreme Court decision, it already brings out all of the anger and all of the criticism. Boy, is it going to be fun to cover West Memphis 3. You guys are really putting on the hard sell to cover that case.
Truth hurts, man. People can't take the truth. I mean, if there's one thing we've learned, it's that.
Oh, with that, do you want to do any questions today?
Sure, let's do a question.
And as you guys know, if you leave a 5-star review, either on the prosecutors or here at Legal Briefs, you get to ask a question. And you know what? We don't really track it. So if you go back and keep editing your questions, we keep answering your different questions. We're really not all about, we're not about the process here.
This one's easy. So we'll do this one and do another one. I think this person thinks that our lives are much more glamorous and complex than they are. GC wants to know, what's a day in the life look like on recording day?
Really not different than any other day. Except I might brush my hair that day.
Yeah. I mean,
so let me walk you through the glamour of our lives. Brett texts me or I text him, free tonight? Sure. Are your kids crazy tonight? Yeah. 8:30? Okay. Maybe 8:45? Okay.
We throw up a post on Patreon last minute. Hey guys, we're going to actually record tonight or tomorrow. I mean, sometimes we do it a whole day ahead. I mean, which is like us planning. But really, we usually prepare for each episode before the actual day of. So when we actually record, this is the beauty of recording with someone that you're very good friends with, is we basically get on and just talk to each other after we've already decided, okay, we're going to cover this week. So we have a general idea of what we're going to cover during the week. And then we honestly just find time in our schedules where both of us are available those nights to be able to record, because we have, our day jobs that sometimes require us to travel or work at night. And if our schedules align, then boom, it's recording day. Boom. Okay. Unfamous Jack wants to know, have either of you ever had to dismiss all charges in the middle of a trial because the defense lawyer proved their client innocent, a la Matlock? No, far more common. And what actually happens not infrequently is the defendant decides to plead guilty in the middle of trial or right before trial, which is always the most annoying.
Ugh.
I mean,
you've stayed up all night. You got all your witnesses there flown in from everywhere. You've worked on your opening statement. They're like, I'd like to plead guilty. That happens actually a lot.
Yeah. I mean, one time we had sat the jury. And the guy pleaded guilty. And then, of course, a week later, he wanted to withdraw his guilty plea. And we were like, no. That's not going to happen.
You can't do that once your jury's impaneled.
And as the judge said, I think what happened in this case was he looked over that jury and he thought, "There's no way these people are going to buy what I'm selling." So he decided
That's
to
so
plead
true.
guilty.
We have had situations too where we have finished our presentation and it's before the jury gets the case, whether it's the prosecution rests or they've rested. But like there, you would think if you go all the way through trial, you would just roll the dice and see what the jury says. But remember, the whole time your counsel is looking over at jury, seeing how they're reacting. And jurors, especially if they're sitting there for multiple days, don't always have poker faces. They'll let you know when they're not buying what you're selling. And so some people, after they've seen how everything plays out in court, how the witnesses play out on the stand, how the jurors respond to kind of the different answers and the different theories that they're trying to throw at the wall. And they're like, you know what? It's going to be guilty. So let me plead out now to try and get a deal with the state.
And look, I mean, you pretty much get credit for pleading guilty no matter when you do it. I mean, if you plead guilty before the foreman of the jury walks in and says guilty, you're going to get something. I mean, I had a case recently where there were two defendants and the co-defendant really needed to plead guilty. Should have pled guilty from the beginning. For some reason, didn't want to plead guilty. Halfway through, was still thinking about pleading guilty. And we made very clear to the defense attorney, look, if they want to plead guilty, we'll let them have all the credit. They want to do that because, they were less culpable than the other person anyway. And really should have been testifying as the other person, but they didn't want to do it. And, we need to, I guess, have we done one on guilty pleas? Have we done a legal briefs on guilty pleas?
We did one on Alford, right?
Did we do one on Alford? I'm not even sure we did one on Alford.
I thought we did North Carolina versus Alford. Or maybe we explained Alford in one of our cases. But I don't
feel
know
like
that
we're explaining it all the time. I'm going to have to go back and look.
I can't remember, honestly. I thought
have
we
done
did
sentencing?
Alford.
We haven't done sentencing
I don't think we've done sentencing. Sentencing could take up like a month.
We did jury selection and we did grand jury. And we did the whole
way through the process.
Well, we did the whole process thing. We did the one episode that had like the entire process of a case. But I don't know if we've done guilty pleas and sentencing. We should do that. Because guilty pleas are interesting.
You guys are seeing how we decide recording days right now.
Right, exactly. The psychology of guilty pleas, why people plead guilty. Some people think it's too easy to plead guilty and it's becomes
when you do
coercive. When you do it, what you get from it. The difference between pleading guilty and pleading guilty with a deal. Because just because you plead guilty doesn't mean you have a deal. I mean, some people think, for instance, if you're in a death penalty case and you plead guilty, the death penalty is off the table. No. You can plead guilty and still get the death penalty. Usually you don't. And usually you make an agreement to take that off the table. But it's complex. And you can imagine if you're the person and you're having to decide whether or not to plead guilty. I mean, what a whirlwind of emotions that is. And we see that play out live.
Here's the thing, kind of going back to that original question, part of the reason you're probably not going to have a situation where the defense proves that they're innocent, so you have to dismiss all your case, is that if the defense counsel has a Matlock moment, they don't want to keep it from you. They don't want to go to trial with their defendant because they want to be able to show you on the front end that you got it wrong and they want to get it dismissed right away. So if they have some sort of like absolutely get out of jail free card, like he has the rock solid alibi and here's all the evidence, they're going to present it to you early on. They do not want to wait until trial to do something like that because so much is in the air and they also have to drag their client through like this entire process when they could be out of jail much earlier.
Okay, we'll do one more. This is from Keith Noley. We got a ton now, so I feel like we should get through some of them. When each of you started law school, did you know you wanted to work for the government? Did it just play out that way, career opportunity-wise? Did you ever consider being defense attorneys? I mean, technically, I started out as a defense attorney. If you count working for a big law firm as defense attorney, I was a defense attorney in that perspective, defending, massive corporations, which was not a lot of fun. I say this sometimes. My criminal law professor in law school used to say to us that we were more likely to be criminal defendants than criminal lawyers, criminal defense lawyers.
Ouch.
Yeah, which I thought was funny.
Which is, wow, kind of true.
Yeah, one of my friends in that class is like a top flight public defender. I mean, so,
I was going to say, but wasn't he also on the what's his name? American Nightmare guy?
That was not one of my classmates.
I know, but he was there. He was there at the same time.
He was. And who knows? There probably was one of my classmates who's in prison right now, and I just don't know about it. But I don't know if I would be a defense attorney. I don't have any problem. I would not have any problem being a defense attorney. I don't think. I mean, I like being on the prosecution side, but I think I could be a defense attorney. I would just tell it to my client straight. I mean, I would just let them know like we have a couple of these defense attorneys, and I really appreciate them, who are just absolutely, and some of their clients don't like them and they'll fire them because of it, but they are straight down the line with them. Like, if the evidence is vastly overwhelming and they're going to lose, they tell them, you are going to lose, you need to plead guilty. And that is so much better representation than an attorney who's like blowing smoke and telling them, no, like, I'm, through the power of my oratory, I am going to win for you, right? So, but I don't know if I'll ever actually end up being a defense attorney, but I would do it. I don't have a problem with defense attorneys. What about you, Alice? I mean, you are a defense attorney, I guess.
I guess so. Although my first job was being a defense attorney for the government. So I think if you're talking about public service versus private practice, I didn't know if I'd ever practice, but I think I always had these rose-colored glasses about public service because you guys have heard my story of being like a child of immigrants and just being really grateful for living in a country that basically allowed me to be, kind of whoever I wanted to be. Whereas my cousins who grew up in like 5 other different countries didn't have that same opportunity afforded to them. So I don't know, I just felt like a lot of pride and patriotism and wanted to give back in that way. So I did always want to work for the government. But just so you know, just because you work for the government, you can be on the defense side as well. It's more public service versus private practice.
Yeah, I mean, I always did want to do public service. I just like trying to use my powers for good, as it were.
Yeah, and when you defend the government, I mean, the government gets sued all the time. So I started out defending basically all the policies of like the government, right? Like you can imagine every time the government does anything, whether it's like a hot topic or not, is going to get sued because someone's not going to like it. And so, yeah, that was a lot of fun because all of that is going to be first impression. Almost all of it goes up to the Supreme Court. You have to be really thick-skinned because they usually are very well stacked in terms of like the best attorneys on the other side, and they come ready to fight because their clients, who are usually big companies, do not want whatever law you've passed to be able to be upheld because it hurts them in some way, which is why they've challenged it. So it was a lot of fun, both being on the defense side as well as being on the prosecution side for the government.
Yeah, and not to wax all poetic, but I mean, the great thing about being a lawyer in the United States with our system, the adversarial system, is really everybody's kind of doing public service if you think about it, because the system only works if you have really good lawyers on both sides. I mean, so we talk about this all the time. That's why we have that whole legal briefs episode about public defenders, right? I mean, you really want really good lawyers on both sides. If you can get really good lawyers on both sides of every case, I mean, that is the ideal situation.
And it's fun.
And I think, yes, it's
fun.
It's
like playing chess against a really good chess player. Like it's engaging, and you're both at the top of your game, and you're challenging each other to be better within the bounds of the rules. It's not fun to play with someone who cheats, for example.
Yeah, or doesn't know what they're doing. I mean, weirdly, sometimes it's almost easier in some ways. Like, I don't know, those of you who play chess, sometimes playing against somebody who has no idea what they're doing is difficult because they're just doing things that don't make sense. They're doing silly things, or they don't really understand how the law works, or they're bogging down the case with these sort of frivolous motions that everybody knows aren't going to work, but now you've got to reply to them and just all this stuff. I mean, no, anybody out there who thinks that defense attorneys may want bad prosecutors, I don't know, but I think good prosecutors want good defense attorneys because it streamlines everything in a way, and it really gets to the heart of the matter. And the same thing what Alice was talking about. I mean, you have lawyers who are defending the government. I mean, the government is supposed to be making rules for the benefit of the public, right? So when you're defending those rules, you are defending the public. But you also have these entities that are affected by them and think that they're unfair. And, they have shareholders and workers and consumers and everybody else they're concerned about too. So in a lot of ways, the system really can work in a way that's supposed to generate good for everybody. Obviously, I know that's a little bit of Pollyanna view of things. It doesn't always work that way, but I would like to think that all of us poor derided lawyers out there, everybody's always making lawyer jokes, that we're all working for the betterment of the world. What do you think, Alice? Betterment of the world? Is that
I think so, but I'm a Pollyanna, and I definitely am called that all the time. So yes, I think so. Well, there you have it. Got a little West Memphis 3, got a couple questions answered, and everyone's off to the races fighting about West Memphis 3. And all we had to do was talk about statutory interpretation. Mission accomplished. With that said, Brett, do you have anything you'd like to add before we sign off for the day?
I'm just looking forward to the next 47 episodes. It's going to be amazing. I guess we should make it 48 so it's even. 47s. That'd be weird. Or maybe even 50. Can we get to 50? Probably.
Oh my goodness. You're not selling it to me. But guys, if you have thoughts about today, feel free to email us at prosecutorspod@gmail.com. Reach out to us on social media. We're on X, we're on Facebook, we're on TikTok even. We're on Instagram, and we're at prosecutorspod. We love hearing from you. We really do read it. Sometimes we might forget to respond, but it doesn't mean we haven't read it. We love hearing from you. Tell us what you want to hear about next. Not West Memphis 3, something else. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
I mean, we can probably get 3 episodes out of Mr. Bojangles alone.
I really do like playing with everyone about West Memphis 3, though. It's really fun.
Yeah. And like snapping turtles. I mean, you can do a whole episode on snapping turtles. Like, was there a wrestling match that night or not? Who knows, right? It's a complete mystery.
All of this. All I'm saying is you guys are really making the case for us to do it, not.
Yeah, people are just so ridiculous about this
Why
case.
are people so angry about this case? My goodness.
I don't know.
I think there are so few things in this life that are not like directly related to me, like something that is my life that gets me this fired up.
No, but I tell you what,
do about certain cases.
I really enjoy making people mad. I mean,
I'm clearly not. Here's the thing: I don't have time for
really
social
get
media,
a kick out of it.
So like, y'all can't touch me because I don't know that you're mad at me because I have a life.
See, that's the thing. Like, Alice pays no attention to the social media at all.
I pay some attention, but who has time, y'all?
Barely any. Though the little
because everyone wants to hate on us. And like if I wanted to find all the hate out there for us, I wouldn't have enough hours in a day. So I choose to ignore the hate.
Yeah, Joe, that is so true. No, like Alice notices social media usually when I've gotten people stirred up about something. She's like, what is going on?
What did you do now?
Like, oh, I mean, just no, it's great.
Getting us in trouble again.
I just, I don't know. Like if people come here to get some like boilerplate what you expect to hear thing, that's not going to happen. I'm sorry. I'm not here to stroke your egos and make you feel better.
Honestly, about every case that we've ever covered, I don't go in thinking anything because I haven't heard of the cases before we do them.
Let's just be clear for those of you, the 59 of you who are still in the room. Alice doesn't know anything about West Memphis 3.
Nothing. I know nothing about West Memphis 3.
Anything about it.
I can't even emphasize how much I don't know about it.
She could not name the 3.
No, of course not. Of course not. And you know what? That is the way I approach these cases on purpose. I don't go read Reddit. I don't go listen. I read the case file because that's what we do when we get a case. That's what we ask the jurors to do. Don't go do your own research about what everyone else is interpreting, right? What do the facts say in this case? So yeah, that's just the truth. And that was the truth about Adnan. I care one way or the other about Adnan.
If we do it and we think they're guilty at the end of it, we are going to tell you that they are guilty. So if you want us to cover this case, just know that if we get to the end of it and the evidence, not the documentaries, not the books, not the shiny statements by Pearl Jam, say that they're guilty, that's what we're going to say. And on the other hand, oh yeah, Eddie Vedder, big supporter. On the other hand, if when we get to the end, we don't think they're guilty, that's what we're going to say. And it just doesn't matter to me who gets mad about that or how mad they get. Well, that is what's going to happen. And that is the only promise we've ever made to you is we will not lie to you. We will tell you exactly what we think about any case we look at.
And here is why this opinion, this Arkansas Supreme Court opinion, confused me so much because I don't know anything about this case. The facts that the dissent puts out and the majority puts out, that's the extent of the facts I understand about this case. And so when I was reading this, I was like, this is not a statutory interpretation case. Like I literally read it and I was like, I don't understand. They said it was habeas. This is against their jurisprudence. And I read it 3 times because I was like, this just makes no sense as a legal opinion. It wasn't because I cared about Damien Echols and his position and testing. I don't even know what they want to test. I literally have no idea what they want to test. But if you're talking about statutory interpretation, this is a confusing opinion. And I just want to point that out because if you have a law student reading this, trying to learn about about statutory interpretation, they're going to like fail their statutory interpretation class. So just like be warned. And I think that's helpful to know, because for so long you think that everything you read is exactly what they're telling you. And like the older I get, the more I realize like people say whatever they want and call it whatever they want, and they co-opt language and define it as they want. And that's why oftentimes like language is very confusing, not just because it's my second language.
Yeah, I mean, and that's the thing with courts. It's always fun to sort of see how they support their reasoning. I mean, because that's the thing. I mean, court opinions are reasoning. That's what's great about the courts, as I think it was Madison said, or Hamilton. Maybe it was Hamilton, that the Supreme Court, the judiciary, was the least dangerous branch because it doesn't have armies, can't pass laws. All it can do is convince you that it's right. And the reason you, at the end of the day, I mean, the reason that you uphold it is because the reasoning's good. And if the reasoning's bad, then eventually some other court's going to overturn it. You know, like the opinions that endure tend to be the opinions that at some point, even if they're not initially, become unassailable. And then other things fade away because even if it takes decades, you know, eventually people see through it. I mean, it's something like Plessy versus Ferguson, which is an 8-1 opinion. I mean, you got eight justices, and there's one guy who's like, yeah, I don't know about this, guys. This seems to be contrary to the Constitution. And it took a long time. I mean, it took 60 years, but eventually that was overturned by a 9-0 opinion. And I think that's why I like the law, because I like the reasoning. So when a court does what I think this court did here, I think it's worth pointing it out. Like, hey, I mean, this is pretty outcome based.
And look, they get to do it. They are the Supreme Court. You know, like we're just a couple of podcasters. Like, whatever, we don't get to decide it, but like you're allowed to understand how statutory interpretation works. And we're not the only ones who think this. And this happens. This happens not just at the Arkansas Supreme Court. This happens in lots of courts. This happens sometimes at the Supreme Court, you know? And I think it's important to know enough to be able to recognize when that is happening, to form your own knowledgeable interpretation of what's happening.
And I mean, we will do it eventually, guys. I don't know where this idea came that we were never going to do West Memphis 3. We're going to do West Memphis 3 eventually. Now,
it might be 2026.
I'm hoping this podcast has a lot of longevity, so it might be a while, but we'll do it eventually. And Paradise Lost, some people are discussing Paradise Lost in the chat. The first Paradise Lost is really good. And I think you can watch the first Paradise Lost and come out either way. I really think you can watch the first Paradise Lost and think that at least Damien is guilty, even if you think the other two aren't. Or you can watch it and be absolutely convinced that a horrible injustice was done. Paradise Lost 2 is trash, as Joe says. Absolute exploitive trash. And if you want to see an example of just horrendous money-grabbing documentary, Paradise 2 is your go-to. And then you got West Memphis, which is obviously they were in the bag. Yeah, it's an advocacy piece for the West Memphis 3. And then Paradise Lost 3, which brings everything around, and sort of it and West Memphis are very similar. And then the book, The Devil's Knot. If you haven't read The Devil's Knot, obviously from someone who believes West Memphis 3 are innocent and is honest with you from the very beginning. That's what she thinks. Very well written. I really enjoyed that book a lot. So if you're looking for things to look at while you await our eventual, inevitable coverage of this case.
Don't leave them on. We don't know when it's going to be.
I don't know when it's going to be. It literally could be years from now.
Is that your way of getting people to listen to us for years?
There you go. You never know.
Oh gosh, guys, this is not a play on that. It's just that it's a huge case and it takes a very long time.
Yes, it will take.
We might have to wait for our kids to like be a little more self-sufficient so we have time to research.
Yeah. I think Gina needs to spend a little bit more time with the record if she thinks there's no evidence against the West Memphis 3.
I mean, it was kind of detailed in this Arkansas opinion. Like I said, I haven't read the whole transcript yet, but
Jesse Misskelley's confession, which didn't even come in the trial of.
We're not going to get into this now, Brett. It's going to be 100 episodes. Wow, this has been fun as always.
This has been fun. We will talk to you guys soon. Alice, I want to record one thing with you after we
Okay.
let everybody go.
Okay.
But we'll see you guys soon. Thursday, probably, right, Alice?
Probably Thursday. Yeah. I can do
So,
Tuesday if you need. I just have to get up really early.
no, let's do Thursday. Thursday's fine. Thursday, for those of you who want to know who DB Cooper is, you will find out
We will solve the case.
on Thursday. So we'll see you guys then. All right. Bye, everybody.
Bye, guys. I'll stop your recording.
Okay, you ready to do
it's
part
almost
1 of
too late
37?
here. 1 of 37. Yeah, let's get started on why
West Memphis 3, baby.
West Memphis 3 and how we are going to exonerate them
20.
all.
24 and 25 is all we're doing.
24 and
no
25.
more, no more cases till 2026.
So just shut it down now if you think you're going to get another case.
That's right.
Oh my goodness.
Okay, let's see. What was I
Okay,
doing
I have
before
to-
we started making
That was a joke,
jokes?
y'all. Don't quit our podcast.